Former Trump attorney John Dowd confirming to Fox News special counsel Robert Mueller warned he could subpoena the president, forcing him to testify before a grand jury if Trump refuses an interview with Mueller's team. President Trump tweeting, "There was no collusion. It is a hoax, and there is no obstruction of justice. That is a setup and trap." Alan Dershowitz is a Harvard Law professor emeritus and the author of Trumped Up: Criminalization of Politics Endangers Democracy. Professor, we appreciate your time this morning.
Thank you.
A huge story and a huge development in all of this since Fox News has been able to confirm that is a possibility, and he has thrown that out there. Will Robert Mueller try to force the president's hand?
Well, many, many months ago on Fox, I said that was going to happen. That's why Mueller has the ultimate card in his hand, the subpoena card, because if you subpoena the president, he has to go in front of the grand jury without his lawyer, without any opportunity to limit the questions. But it gives the president some options, too. He can challenge the subpoena in court. He can go to the federal district court, the Court of Appeals, the United States Supreme Court. He can argue, A, that you can't subpoena a president in a criminal case in front of a grand jury. You probably lose that broad issue. He can then argue that you can't ask a president why he engaged in acts that are authorized under Article 2 of the Constitution. He may well win that argument. And then he might argue that you can't ask me questions that go beyond the scope of the special counsel's authority, namely to my business dealings, before he became president of the United States. And he may win or may lose that. It's unclear. But I think he'd be in a better position challenging this legally than sitting down with the special counsel and answering that list of 40-some-odd questions that are so open-ended, so vague, and so general.
Yeah, if I could get your take on that, because, the confirmation of this possible subpoena is coming just a day after we learned about and obtained the list of questions that Trump's legal team believes Mueller wishes to ask him. What did you think when you went through each of those questions?
Well, I thought they were not well-crafted questions. They probably weren't crafted by the prosecutor. They were probably just notes taken by the defense team, but they certainly show areas of interest. They show me several things. One, they show that Rod Rosenstein must be recused from any further participation in the obstruction of justice part of the case because he's a central witness. I asked him the question, why did you fire Comey? And the obvious answer is because I got a memo from Rosenstein. Why don't you ask him why he wrote me a memo telling me that I can fire Comey? So it seems to me that these questions put a real onus on Rosenstein to recuse himself.
Do you have any idea?
Second, they tell me that there's no limitation on the questions. They can ask questions in any areas. And third, plainly, they want to ask him questions that give him an opportunity to ramble on and perhaps give them information they don't have or say things that are contradicted by information they do have.
If the president agrees to the subpoena, you're saying he has the ability to fight it, and you listed the ways that his team could do that. But if he agrees to the subpoena and sits down to these questions, where does this end up?
Well, it depends on what he answers. I mean, I think if I were the president's lawyer, and I'm not, let me be very clear about that, I would take advantage of these questions, and I would submit answers in writing to almost all of them, and then make objections to the others based on Article 2 of the Constitution, and then tell the American public, look, I've answered all these questions. Why are they trying to bring me into a grand jury? This interferes with my right to govern, and I think he would be in a better position politically and perhaps even legally if he were to provide answers to the questions. Remember, one of the reasons they want to haul him in front of the grand jury or ask him questions is because they want to see if he's going to lie. This is a perjury trap in some ways. And it's not a proper role of the grand jury to set perjury traps for subjects of criminal prosecutions. The role of the grand jury is to obtain information they don't already have, not to give the subject an opportunity to lie about answers that they do already have.
I want to go back to, initially the report out that the idea of a subpoena was floated by Mueller in this meeting. John Dowd was there. He was then the president's lead attorney. He apparently retorted, quote, "This isn't some game. You are screwing with the work of the president of the United States." And as we know, Dowd went on to resign as the president's lead lawyer just weeks later.
Yeah, well, I think the reason that it is given for why he resigned, and I understand it, is he gave advice to the president, namely not to willingly testify. And the president said publicly that he wants to testify. And, you know, if you're going to be somebody's lawyer and you're in a trusted relationship, there has to be trust on both sides. And there has to be a willingness to accept the advice of the lawyer. And so I understand why Dowd left the case as his lawyer. And I would think any good lawyer at this point would advise the president to do everything in his power not to testify unless he was compelled by a court to do so.
Each time is obviously different, but historically, have other presidents faced subpoenas?
Well, it's interesting that, of course, President Bush never faced a subpoena for pardoning Caspar Weinberger and 5 people on the eve of their trial, even though the special prosecutor in that case said that was part of a cover-up, an obstruction of justice, an attempt to end the investigation. But nobody dreamed of subpoenaing the president for that. President Clinton was subpoenaed, but for matters relating more to his alleged sexual activities than for matters of governance. But and of course, Nixon's tapes were subpoenaed, so we have some precedent on all sides of this issue. But you know, every case involving a president is different, and it's hard to predict how this Supreme Court would come out if the president refused to answer specific questions that went to his state of mind about why he engaged in acts that are constitutionally authorized under Article 2. I think that would be a very strong, a very plausible argument he could make to the Supreme Court.
We certainly value getting your perspective on all of this morning, Professor. Thank you for your time. Alan Dershowitz.
Thank you.